when most airman enforcement cases arise in practice. Hello again, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now let's turn to the second major issue, where airman enforcement cases most commonly arise in the real world. It's important to be careful here because the FAA does not publish a simple single table that says all airman legal enforcement actions break down into neat percentages by allegation, per se. But based on the FAA's guidance, the categories in order 2150.3C and the recurring body of published NTSB airman decisions, the same clusters of enforcement actions appear again and again. The first cluster is pilot deviations that are visible to air traffic control or otherwise easy to reconstruct after the fact. And this means altitude deviations, airspace incursions, failure to comply with clearances or instructions, runway incursions, and related careless or reckless charges under Section 91.13 is especially important because the FAA's catch-all risk rule is often charged residually with another operational violation. A busted clearance may become a Section 91.123 case, but it often arrives with Section 91.13 attached because the FAA frames the deviation as creating actual or potential endangerment. A published example is Leaschauer. In this case, the NTSB affirmed a 155-day suspension after the pilot entered into San Francisco Class B airspace area without clearance and did so without holding a valid medical certificate. The board also sustained the Section 91.13 charge because the operation created potential hazard to others. That example is useful because it shows how these cases really work. One event rarely produces only one count. A single flight can trigger an airspace violation, a qualifications violation, and a careless or reckless allegation all at once. The FAA loves to assert careless and reckless. It's almost always included. The second recurring cluster is record-based enforcement. These are cases built not from what FAA air traffic control saw or heard, but what the airman signed, logged, endorsed, or omitted. This is where intentional falsification becomes existential. Under 14 C.F.R. Section 61.59, and in medical cases, Section 67.403, the FAA and the board treats intentional falsification. It's a fundamentally integrity offense. The case Hart versus McLusis asks whether there was a false representation, whether a concern, the material fact, and whether the airman knew it was false. The consequences here are severe for a reason. The FAA regulatory system depends on truthful records. If the agency cannot trust the logbook endorsements, the medical application, the training sign-off, or the test application, it sees the problem not as a paperwork issue, but as a qualification and judgment issue. A strong example is the board's decision in Jones, where the NTSB explained that the Hart-McLucas test governs intentional falsification cases. Another is the board's decision reported at order number EA-5490, where a false flight crew endorsement supported revocation because of intentional falsification. And intentional falsification is treated as grounds for revocation. Remember this point. In FAA enforcement, a bad landing may be survivable, but a bad record can be disqualifying. The third recurring cluster is medical and alcohol-related matters. These cases are often misunderstood because some begin on the ground and not in the aircraft. Under Section 61.15, an airman must report each qualifying motor vehicle action involving alcohol or drugs within 60 days. The FAA separately treats multiple motor vehicle actions within 3 years as a certification issue. And under Section 91.17, acting or attempting to act as a crew member while under the influence of alcohol or with a prohibited blood alcohol concentration can lead to severe certificate consequences. That means a DUI event can become several different aviation problems at once: a motor vehicle action reporting issue, a medical certification issue, a judgment issue, and sometimes a direct operational issue if flight activity is involved. Airmen get into trouble when they think the driving matters only belong in traffic court. The fourth recurring cluster is qualification drift. This is an airman who flies without the required medical, without current qualification, without proper endorsement, or beyond the privileges of the certification held. These cases can look minor from the cockpit and major from a regulator's desk because they go directly to whether the pilot was legally entitled to act at all. There is also an important lesson in the old Brasher line of cases. Pilots sometimes believe that if air traffic control does not immediately advise them of a possible pilot deviation, the FAA case disappears. That's wrong. The board has made clear that immediate deviation notice rules are limited, and lack of notice is not a universal defense. So where do most meaningful airman enforcement matters arise? In my view, supported by published authorities, they arise when the government can prove the case from objective data, radar, audio, records, applications, endorsements, and other official reports. That is why operational deviations and falsification show up so often. They are provable. The bottom line is simple. Most airmen do not face serious FAA trouble because they set out to violate the rules. They face it because one deviation created data, one form contained a bad answer, or one effort to smooth over the facts turned a manageable event into a certification case. I'd like you to take this away. The FAA's strongest case against airmen usually begins when the facts are recorded before the defense is even written. Before you respond to the FAA, you should stop, think, and then respond. Keep in mind, this information is provided for informational purposes only and should not be construed as legal advice. If you have any questions, please direct them, and they're welcome, at admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.